Madam Acting Speaker, Michael Gallacher was a Liberal Party member of the Legislative Council, Leader of the Government Legislative Council, Minister for Police and a former police officer with a long-standing reputation for integrity. On the 2nd of May 2014, at a public hearing of the ICAC, Counsel Assisting Geoffrey Watson SC put to a witness he was examining, asserting that the witness and Mr Gallacher had, quote, hatched a corrupt scheme, unquote. The assertion that Mr Gallacher had acted corruptly was made without any prior warning while the Minister was attending an access class inspection of police at the parade ground at the New South Wales Police Academy at Goulburn. The consequences of that assertion caused the then Premier to demand a resignation of the Minister, who for the remainder of his parliamentary term was required to sit on the crossbenches of the other place and not be permitted to attend Liberal Party room meetings. Mr McClintock SC, the Inspector, has concluded, following an audit of ICAC, that the question was, quote, inappropriate and unfair. His evidence to the committee was that he'd examined the documents of which ICAC relied to make the allegation that Gallacher was involved in, quote, hatched a corrupt scheme, unquote, and he concluded such assertion was not warranted or justified. The Inspector concluded that it was a serious lapse of procedural fairness. Due to the practical effect of it, I regard it as a serious interference with the state's democracy. The Inspector concluded, quote, unfortunately the examination of Mr Williams is not the only example of the conduct of Operation Spicer which I consider to be unsatisfactory, unquote. And he gave a variety of examples. And he then concluded that whilst he considered Mr Watson's conduct to be inappropriate and unfair to Mr Gallacher, that was, however, a failure of process and not a failure of substance. He found that the failure of process does not seem to him to have had any effect on Mr Gallacher's conduct, which could be, quote, supported independently of Mr Watson's questions to Mr Williams. I reject the Inspector's conclusion. The fact is that ICAC, arising from the decisions of the High Court in Cooneem and some amendments enacted by this Parliament, had no jurisdiction to make any corruption findings against Gallacher. If it did not have such jurisdiction to make such findings, what was its legitimate forensic purpose of making factual findings against him? Findings of fact made not on admissible evidence and made in circumstances when Counsel Assisting's conduct in a number of areas had been found by the Inspector to be inappropriate and unfair. The bar rules as they then were required Counsel Assisting to conduct themselves as if the Commission were a court, quote, must act fairly to assist the court to arrive at the truth, quote, not by language or other conduct seek to inflame or bias the court against the accused. No court would, except in the most exceptional circumstances, allow a conviction or finding to stand against any person after it concluded counsel or the prosecutor conducted them unfairly. I have unresolved concerns about the Chief Commissioner's letter he wrote to the committee shortly after the Inspector gave evidence, but I am ethically bound not to comment at this stage whilst the Commissioner has before him an investigation into the Labor Party in relation to conduct and the conduct of Caleb Manane, who was once close to me prior to the recent leadership contest. I'll wait for that report to be given before I pursue the matter further. As no finding was made against Gallacher, he has no remedy. Parliament gives enormous coercive powers to a corruption-fighting body as it accepts that serious public sector corruption cannot be uncovered by traditional law enforcement means. While I accept the evidence of the Inspector that the amendments to the Act, the requirements of procedural fairness and the high quality of appointments of the current Commissioners will not see a repeat of these legacy issues, I'm not satisfied that the appropriate checks and balances for the future are in place to prevent significant reputational damage to people. As a criminal lawyer from the area where it took the High Court after decades to effectively stop law enforcement agencies fabricating confessions, the Premier's Department referred to agency capture when it suggested the three-commissioner model as one check and balance. We need a structure in place for the future when the current occupants move on. Do I really have to remind the House that the previous Commissioner was effectively sacked by legislation opposed by the Labor Party? Effective checks and balances have to be a continuing process.